I'm Nick Brooks, a California employment law attorney. Can an employee's resignation count as a firing? Absolutely, and it's called constructive discharge. Today, I'm breaking down California's constructive discharge doctrine, when resignations become terminations, and how employers can avoid massive liability under California Government Code Section 12940. What is constructive discharge? Well, in California workplace law, termination does not only occur when an employer explicitly fires someone. In some situations, an employee's resignation may be legally treated as a firing if the employer's conduct created such intolerable conditions that the employee had no reasonable alternative but to quit. For employers, constructive discharge can carry the same legal consequences as wrongful termination. California courts define constructive discharge as a resignation that's legally deemed a termination because, first, the employer intentionally created or knowingly permitted intolerable working conditions. Second, the conditions were so aggravated that a reasonable employee in the same situation would feel compelled to resign. Third, the employee in fact quit because of those conditions. The test is objective, not whether this particular employee felt they had no choice, but whether a reasonable person would feel forced out. How intolerable must conditions be? Well, the bar for constructive discharge is high. Conditions must be unusually aggravated or involve a continuous pattern of mistreatment. Single, trivial, or isolated incidents typically are not enough. However, in extreme cases, such as violence against an employee or an illegal ultimatum, a single event may suffice. Now, for some examples that may qualify. Potential constructive discharge situations include persistent retaliation or harassment known to management but not corrected, ongoing denial of disability or religious accommodations, leaving that employee unable to work, or a sustained campaign of hostility, unjust criticism, or stripping of duties that makes continuing employment untenable. These are some examples of what's typically not enough on their own to constitute constructive discharge. First, a poor performance evaluation, even if the employee believes it's unfair. A demotion or pay cut standing alone without other aggravated mistreatment. Or an occasional dispute, negative comment, or isolated disciplinary action. Employees must be driven out by conditions so severe that continued employment is not objectively reasonable. Constructive discharge exposes employers to the same liability as an outright termination, including wrongful termination claims if resignation is tied to discriminatory or retaliatory conditions, FEHA claims under Government Code Section 12940, since constructive discharge can constitute the adverse employment action required for discrimination and retaliation cases, plus back pay, emotional distress damages, and attorney's fees. Here are some ways that California employers can reduce constructive discharge risk. First, respond quickly to complaints. Promptly investigate and resolve reports of harassment, retaliation, or discrimination. Next, avoid pushing out employees. Negative treatment designed to encourage resignation may be reclassified as a firing. Third, document accommodation and corrective actions. Fourth, train managers on what creates intolerable environments. And finally, seek legal guidance, such as from myself, when employees resign amid unresolved conflict. Constructive discharge ensures that employers cannot sidestep liability by making working conditions so unpleasant that employees quit on their own. California law treats such resignations as firings with all legal consequences that follow. For more information about this legal issue, please visit my blog at nickbrooksesque.com. That's nickbrooksesq.com. And subscribe to my YouTube channel for more California employment law tips. Thank you very much.